Hello friends, welcome to Prashant IAS. So friends, in the last class, we have discussed till Article 21 of the Indian Constitution. And from this class, we will continue our discussion with Article 22 of the Indian Constitution. So friends, what is Article 22 or what Article 22 says? So Article 22 provides protection against arrest and detention to an individual. So what is Article 22? So Article 22 says that it provides protection against arrest and detention to an individual. Now what does it mean? So friends, it does not guarantee any fundamental right against arrest. Okay, it does not guarantee any fundamental right against arrest. Means it does not stop police or government from arresting you. So Article 22 does not stop police or government from arresting you. So now you will ask, sir, then what is the function of Article 22? So Article 22 provides you protection when police is arresting you. Okay, so Article 22 provides you protection when you are being arrested. So Article 22 provides protection to an individual when he is being arrested or he is being detained by the police or government. For example, friends, people from many religions wear different symbols and amulets. Okay, amulet means tabij. For example, people who follow Hinduism, they wear amulet or tabij. And people who follow Christianity, they wear cross symbol. So why do people wear these kinds of symbol? So people wear these kinds of symbol or amulet so that if they are encountered with ghost, or any other evil spirit, so this amulet or this symbol can drive the evil spirit away from the person. Okay, so that this amulet or this symbol can drive the evil spirit away. So what is the basis, what is the reason behind wearing an amulet? So the very basic reason behind wearing an amulet is to drive the evil away, is to drive the ghost away. Now what does it mean? So it means that the amulet provides you protection when you are encountered with ghost. Means amulet comes into action when you are encountered with ghost. It means that amulet is useless. Amulet is of no use to you until you are not in front of ghost. Okay, so amulet is useless to you. Amulet is of no use to you until you are not in front of ghost. But when you will come in front of ghost, then amulet will come into action. And then what amulet will do? Then amulet will provide you protection against ghost. The similar concept we can apply with Article 22. Means Article 22 comes into play from the moment of arrest and not before that. Means until you are not being arrested. Means until you are in normal circumstances, till then Article 22 is of no use for you. Okay, so Article 22 is not in action. So until you are not being arrested, Article 22 is of no use for you. But when you are being arrested, at that point of time Article 22 comes into play, and Article 22 provides you protection against the action of police, against arrest from that moment. Okay, so Article 22 comes into play from the moment when you are being arrested. Now friends, what kind of protection Article 22 gives to us? Okay, so let's discuss that what kind of protection actually Article 22 provides to the individuals. So for it, we will study all the clauses of Article 21. So first of all, we will study Article 22 Clause 1. So what is Article 22 Clause 1? So Article 22 Clause 1 says that no person who is arrested shall be detained in custody without informing him the ground of arrest. Okay, so no person who is arrested shall be detained in custody without informing him the ground of arrest. Now what does it mean? So it means that if police is arresting you, okay, then you have the fundamental right to know the ground of your arrest. Means what is the reason why police is arresting you? Okay, so when police is arresting you, it is your fundamental right to know that why police is arresting you. What is the reason? What is the ground on which police is arresting you? Okay, and it is the duty of policemen to inform you about the ground of arrest, that why police is arresting you. So this is the first protection, means policeman cannot arrest you without telling you the reason that why we are arresting you. Okay, so when policeman will arrest you, then policeman has to tell you the reason that on what ground we are arresting you. So this is the first protection. Then friends, person shall not be arrested merely on the ground of suspicion. Now what does it mean? So it means that if police has to arrest someone, then police cannot arrest any person only on the ground of suspicion. Why? Because then police can suspect anyone. Then police will misuse this power. So it means that police should have at least a little proof. Police should have some proof to arrest any person. For example, if police wants to arrest a person in a murder case, then police should have at least some proof. For example, if police have found the mobile or any of the thing used by that person at the spot where murder was committed. Okay, so police should have at least some proof against the person whom police want to arrest. Without proof, police cannot arrest you. So police cannot arrest you only on the basis of suspicion. Police has to have some proof with police. Okay. Then friends, arrested person has the right to inform his family members and friends of the ground of his arrest. Now what does it mean? So suppose if you are being arrested by the police, then it is your fundamental right under Article 22 Clause 1 that you can inform your friends, you can inform your family that police is arresting me. Okay, so you can call your family members, you can send them a text message, but you have the fundamental right to inform them in any way. And you also have the right to tell them that why actually police is arresting me, the ground of my arrest. Okay, so you can inform your friends and family members while you are being arrested. Now friends, once the person is arrested, then he is also entitled to consult a lawyer of his choice and defend himself. Okay, so it is the fundamental right of any individual, of any person, that when he is arrested by the police, at that point of time, he can consult any lawyer, so that that lawyer can give him a good legal advice. That lawyer can guide him. That lawyer can arrange for bail for the arrested person. That lawyer can fight case in the court of law on behalf of that person. Okay, so if you are arrested by the police, then you have a fundamental right to consult a lawyer of your choice. Means the choice of police will not work. You have the right to consult the lawyer of your choice. Okay, then friends, arrest of a person shall be recorded in official diary. Means if police has arrested you, then police has to write in its official diary that police has arrested this person on this date at this time. Okay, so there is a official police diary, so police has to write in its official diary that police has arrested this person. Now friends, many of you must be finding this concept little bit difficult. That's why now I will give you one very beautiful example so that you all can understand it very easily. So friends, here on the screen you can see a diagram, and in this diagram on the left hand side, you can see a person. The name of that person is Pappu. Okay, and on the right hand side you can see a policeman. So now this policeman wants to arrest Pappu. Okay, so now this policeman came to arrest Pappu, but when this policeman came to arrest Pappu, then during the time of his arrest, Pappu has the right to know that why police is actually arresting him. Pappu has the right to know the ground of his arrest. So when policeman has arrived to arrest the Pappu, so now this is the duty of this policeman to inform Pappu that why I am arresting you, that what is the ground of your arrest, what is your crime. Okay, so now first of all it is the duty of this policeman that this policeman will inform Pappu that why I am arresting you. Now friends, suppose this Pappu is suspected of a murder case. Okay, so now this policeman will inform Pappu that I am arresting you as a suspicion in a murder case, that I suspect that you have committed that murder, so I am arresting you in a murder case. So first thing is satisfied. Now Pappu knows that why police is arresting me, and policeman has told the ground of arrest to Pappu. Now second thing is that policeman cannot arrest the Pappu only on the basis of suspicion. Why? Because in this way policeman can suspect anyone. Policeman can also suspect you and me. Okay, so there should be some basis of suspicion. Means police should have at least some proof with it. Police should have at least some proof with them. So now suppose, now policeman will say to Pappu that I have found your smartphone at the spot of murder. Okay, so now policeman will say to Pappu that I have found your smartphone on the spot of murder. Means the place where murder was committed, at that place your smartphone was found. So it means that at least there is some link between this murder and you. Your smartphone was there. It does not prove that you have committed the murder, but at least it proves that there is some link between that murder and you. Okay, and it is a possibility that you have committed that murder, and it is also a possibility that you know who is a murderer. So on this ground I am arresting you. Okay, so now second condition is also satisfied. Means policeman has to tell Pappu that on what ground I am arresting you, and policeman should have at least with him some proof. Okay, then friends, now Pappu knows that I will be arrested. Why? Because policeman has told me the ground of arrest and also he has proof with me. Now Pappu will use his third right. Pappu will say that now sir, I want to inform my mother father that I am being arrested. Okay, so now Pappu will call his mother or his father, and Pappu will inform his father that father, I am being arrested, so please do arrange a lawyer for me so that he can arrange for my bail. Okay, so now policeman cannot stop the Pappu from contacting his family. Okay, so Pappu can contact his family or friends or anyone who Pappu want to contact. Okay, so Pappu can contact his family or friends during he is arrested. Now friends, when Pappu has informed to his family, then policeman has arrested Pappu. So now you can see in next diagram that now Pappu is behind the bars. Means now he is finally arrested. So when he is arrested, so I have told you that he has the right to get consultation by the lawyer of his choice. Okay, so Pappu has the fundamental right to get consultation by the lawyer of his choice. And he has also informed his family that please do arrange a lawyer for me because police is arresting me in the charges of murder case. So it is a very difficult case. So please do arrange a good lawyer for me. So now the family of Pappu arranged a very good lawyer for Pappu, and in the last diagram you can see that now Pappu is talking to the lawyer, and now Pappu can tell entire incident to lawyer, and Pappu can also tell that please arrange for my bail and anything. Okay, so now Pappu can take consultation with the lawyer of his choice. Okay, and definitely police cannot stop Pappu from getting consultation from the lawyer of his choice. So friends, now I hope that you all must have understood by this story that what is Article 22 Clause 1. So friends, now let's move further. So friends, then comes Article 22 Clause 2. So what is Article 22 Clause 2? So Article 22 Clause 2 says that the arrested person shall be produced before the nearest judicial magistrate within 24 hours of arrest, excluding the time of journey. Now what does it mean? So here I gave you the example of Pappu. So now we will continue with the example of Pappu. Okay, so now when Pappu was arrested by the police, so first of all the time of journey will be excluded. Time of journey means the time which was consumed when police picked Pappu, when police arrested Pappu from home and police brought Pappu to the police station. Okay, so the time of journey from the home of Pappu to police station will be excluded, means it will be not count. Then now what does it mean? It means that now it is the duty of the policeman to produce Pappu, to produce the person before the nearest judicial magistrate within 24 hours of arrest. Okay, so it is the duty of policeman to produce the person before the nearest magistrate within 24 hours of arrest, and in these 24 hours the time of journey will not be counted, means the time which was consumed in journey, means which was consumed in bringing that person from his home to police station. Okay, so suppose police arrested Pappu on 25th of January at 9 a.m. Okay, so police arrested Pappu on 25th of January at 9 a.m. Now friends, the time which means the time of journey from the home of Pappu to police station was 1 hour. So policeman reached with Pappu at police station on at 10 a.m. Okay, so now it is the duty of the policeman to produce Pappu before the judicial magistrate. It is the duty of the policeman to produce Pappu before the nearest judicial magistrate before 26th of January 10 a.m. Okay, so on 25th of January at 10 a.m. they reached police station, means Pappu was finally arrested. So now it is the duty of policeman to produce Pappu before the nearest judicial magistrate before 26th of January 10 a.m. Okay, so it is the fundamental right of any person to get produced before a nearest magistrate within 24 hours of arrest. Okay, now friends, what is Article 22 Clause 3? So Article 22 Clause 3 says, no person shall be kept in custody beyond the period for which the detention was authorized by the magistrate. Now what does it mean? So friends, now we were discussing about Pappu. So Pappu was arrested by policemen on 25th of January at 10 a.m. Okay, and policeman produced Pappu before magistrate before, okay, policeman produced Pappu before the nearest judicial magistrate before 26th of January 10 a.m. Suppose policeman produced Pappu before nearest judicial magistrate on 26th of January at 8 a.m. So this time was before 10 a.m. So they produced Pappu before the nearest judicial magistrate on 26th of January at 8 a.m. Now this judicial magistrate has told the police that you can keep Pappu in custody for 10 days. And in those 10 days, you have to interrogate from Pappu that what information do you have about this murder case. Okay, so now what what magistrate has said? So magistrate has said that police can keep Pappu in custody for only 10 days. So now after 10 days, okay, after 10 days, police cannot keep Pappu in its custody more. Okay, so after 10 days, police has no power, police has no authority to keep Pappu in his custody. Now friends, definitely murder case is a non-bailable crime, so Pappu will not get bail and Pappu will also be not released. But I have told you the example of 10 days so that I can explain you Article 22 Clause 3, because after all it was an example, it was an imaginary example. Okay, so according to Article 22 Clause 3, if magistrate has ordered the police that you can only keep Pappu with you and you can only interrogate with Pappu for next 10 days. So after 10 days, it is the duty of the police to release Pappu from jail. Okay. Now friends, these protections are not available to enemy aliens or the persons detained under preventive detention laws. Means the protection provided under Article 22 Clause 1, 22 Clause 2 and 22 Clause 3. These all protections are not available to enemy aliens. Now who are enemy aliens? So suppose if the President of India officially declares a war with any other country, then all the citizens of that country will become enemy aliens for us. Okay, so when police will arrest those persons, then they will not get protection under Article 22. Now what is preventive detention law? So preventive detention law, for example, MACOCA is a preventive detention law. MACOCA means Maharashtra Control of Organized Crime Act. UAPA is a preventive detention law, for example, Unlawful Activities Prevention Act. So these are preventive detention laws. So when a person is arrested under preventive detention laws, then that person do not have any protection under Article 22. Now friends, MACOCA is in news. For example, it was a news in Hindustan Times that MACOCA invoked against 10 persons for slashing man with sword in Mumbai. Okay, and there was a news article in the Indian Express that 2 convicts of 2006 Mumbai serial train blast appealed to High Court against conviction by MACOCA court. Okay, so actually this topic is in news, so there are very high chances that this can be asked in your prelims exam, and definitely question can be asked from Article 22 in your prelims exam. So I suggest you to go use internet and to find the news about MACOCA. Okay, so and try to study these news. Now friends, what is a preventive detention law? So I will give you a very simple example, okay, so that you can understand. You can have an idea that what is a preventive detention law. So suppose in the month of March, what happened? definitely we know in the month of March winter is very less, okay, and it is the starting of summer, so means there is the weather is not cold, weather is somewhere between cold and hot, so we do not need to wear any sweaters, jackets or anything else, shawl, okay. So what happened, friends, in the month of March, suppose that near railway station two persons are sitting, okay, and these two persons are wearing shawl, and definitely it is a common sense that no one will wear shawl in the month of March, okay. Why? Because, or we can say in the month of April, okay. So in the month of April nobody will wear shawl. Why? Because wearing a shawl in the month of April is a very different thing. Why? Because in April there is a starting of summers and nobody wears the woolen or warm clothes in April. So what happened, that two persons are sitting near railway station and they were wearing shawl, okay. So what happened, the SP of city, means superintendent of police. So superintendent of police or SP was passing from there, okay, and SP saw that two people are sitting and these two people are wearing shawls. So definitely anybody can suspect that there is something fishy. Why they are wearing shawl? They are trying to hide something. That's why, okay. So now SP will thought, definitely SP will thought that anybody will thought that there is something fishy. So now what SP did, that he went near these two persons and he forcibly snatched their shawls. And what he found, that these persons were having AK-47 in their hand and they were also armed with RDX. What is RDX? RDX is a very highly explosive material. Okay, so these persons were having AK-47 and definitely AK-47 is banned for civilians. Okay, AK-47 is only allowed for military, paramilitary forces and in some cases to police. Okay, so what SP found, that these persons are having AK-47 and also these persons were having RDX with them. So definitely now SP will think and anybody will think that there is something fishy and these persons want to do something big. They want to do some explosion in the city. They want to kill many people. Means they are terrorists. Okay, so they are terrorists. So this is a general assumption that they are terrorists. So now what SP will do? Now SP will arrest these persons under preventive detention law. So when these persons will be arrested under preventive detention law, then they will get no protection under Article 22. Okay, means there is no need to tell them the ground of their arrest, or there is no need to produce them before a magistrate within 24 hours of arrest and so on. Okay, so they will not get any protection under Article 22. So preventive detention law means that when police arrests you, okay, when police or the government arrests you before doing the crime, okay, means in prevention, okay, in prevention of. So when police arrests you before doing the crime, and on what ground police arrests you? So definitely if you are found with something which by which you can do something big explosion, okay, or anything else. So and what happens in preventive detention law, that a person is arrested before committing the crime. Why? Because these persons have not committed the crime till yet. But by seeing AK-47 and RDX in their hands, SP suspected that now they will do something big. So on the ground that they can do some big harm to the city, SP arrested them. So preventive detention means arresting a person before he has committed the crime. Okay, so there are certain preventive detention laws. For example, Makoka is a preventive detention law, UAPA is a preventive detention laws. Okay, so preventive detention means when police arrests a person before he has committed a crime. Okay, so when police arrests a person before he has committed a crime and police has a very strong suspicion and police has a proof that this person wants to do a very big harm to entire society, this person wants to do a very big harm to entire city. Okay, so and police should also have some proof. Why? Because in that case SP arrested those persons because they were found with AK-47 and RDX and they could use that RDX to explode the entire city. So preventive detention, what happens in preventive detention means a person is arrested before he has committed the crime, and on what ground? on the ground that he can cause a very big harm to the city or any place. Okay, and police also has some proof. Okay, for example, SP had the proof that they were found with AK-47, they were found with RDX. Okay, so here we are not discussing about preventive detention laws in detail, and that's not our topic also. Okay, so I was just giving you some idea so that you can understand. Okay friends, let's move further. So friends, then comes Article 23 Clause 1. So what Article 23 Clause 1 says? So it prohibits traffic in human being, begar or any other form of forced labor. Okay, so what it says? So it prohibits traffic in human being, begar or any other form of forced labor. Now what is traffic in human being or what is human trafficking? So friends, suppose if there is a criminal and if that criminal kidnaps some girls or children. Okay, so there is a criminal and that criminal kidnaps some girls or children, and then if he sells these childrens in the market, okay, if he sells these childrens and these girls, then it is known as human trafficking. So human trafficking means sale and purchase of human beings or sale and purchase of human organs. Okay, so this is human trafficking. So friends, here in this diagram you can see the three examples of human trafficking. For example, in the first diagram you can see that a criminal has snatched a baby from his mother, okay, and then this criminal is running with that baby, and definitely we all know that what this criminal will do this with this baby. So definitely this criminal will sell this baby in the market. Okay, this criminal will sell this baby or this criminal will sell the organs of this baby. So these kind of practices are known as human trafficking. In the second example, you can see a human cage. So in that human cage, a person is behind the bars just like an animal. Okay, and he is definitely treated like a slave. So this is also a example of human trafficking. Now in the third example, you can see forced prostitution. So what is forced prostitution? So in this diagram, you can see that there is a criminal and that person is forcing these girls to do prostitution. And if these girls will not do prostitution, then definitely he can also kill these girls. So he is definitely pressurizing these girls to do prostitution. So this is also an example of human trafficking. So what is human trafficking? So human trafficking means sale and purchase of human beings, or we can also say the sale and purchase of human organs. So this is human trafficking. So friends, Article 23 Clause 1 prohibits human trafficking in all forms. Means human trafficking is banned, and if any person will practice human trafficking, then government will punish him. Means police will punish him. Now what is begar? So begar is a form of forced labor. And now what is forced labor? So friends, here in the diagram on the right side, you can see that there is a big man and there is a small boy. So this big man, what he is doing, that he is holding a chain in his hand, and that chain is tied to the leg of that boy. Okay, and that man is forcing that boy to work for him. So this is an example of forced labor. Forced labor means when a person do not wants to work for you. When a person does not want to work for you and you are forcing him to work. For example, I will give you one more example. So suppose there are two persons, Santa and Banta. Now Santa is very powerful and Banta is weak. So now what Santa is doing? Now Santa is forcing Banta to work for him. Now Santa is forcing Banta to work for 12 to 14 hours. Okay, so now Banta is working for 12 to 14 hours and Santa is also not paying him money. Means Santa is not paying money to Banta. Okay, and if Banta wants to leave, then Santa is saying that if you will leave, then I will kill you. So these kind of things are known as forced labor. Means when a person doesn't want to work and you are forcing him to work. You are forcing him to work for 12 to 14 hours and you are not paying him money. And if you want to leave the job, then you are threatening him to kill, that I will kill you. So forced labor is also banned in all the forms. Means if any person will practice forced labor, then police will punish him. Now friends, then comes Article 23 Clause 2. So what is Article 23 Clause 2? So it empowers the state to compel the individuals to provide service with or without payment, provided it is in public interest. Now what does it mean? So suppose if there is a work, okay, if there is a work in the country and that work is very very important for the interest of India, that work is important for the interest of entire public, then government has the power to pick any individual, and then government can force that individual to give his services. Okay, means then government can force any individual to work. And friends, if government wants, then government may pay him money, and if government doesn't want, then government may not pay him money. Means government is free to give him money or not give him money. Okay, so if there is a work of public interest, then government can force any person to do work. For example, government can force anyone to plant 5 saplings. What is sapling? Sapling means a plant. Sapling means plant. Okay, so government can force any person to plant at least 5 saplings and to look after these saplings, to take care of these saplings. And if government wants, government can give you payment for your work. And if government not want, government may not give you payment for your work. Why? Because planting trees is very very important for fighting with pollution, for cleaning our environment. Okay, because trees are very very important for us. So planting trees is very very important for healing our environment. Okay, trees are very important, we all know the importance of tree. So government can force us for planting trees. So this can be an example of article 23 clause 2. Now friends, then comes article 24. So what is article 24? So it prohibits employment of children below age of 14 in hazardous employment. Now what is hazardous employment? Hazardous employment means any work which is dangerous. So hazardous employment means dangerous work, means in which there is a threat of life, there is a threat to our life. So according to article 21, children whose age is below 14 years of age, children whose age is below 14 years of age, they cannot do hazardous work. They cannot be employed in any hazardous work. So this is article 24. So friends, getting inspired by article 24, Parliament of India passed Child Labour Prohibition and Regulation Act 2016. Okay, so now let's see what is Child Labour Prohibition and Regulation Act 2016. So first of all, it prohibits any employment for children below age of 14 except entertainment industry and family enterprise. Okay, so now what does it mean? It means that children whose age is less than 14 years of age, they cannot do any work, means they cannot be employed in any work. Okay, but there are two exceptions. These children can be employed in entertainment industry, for example films, TV shows. Okay, and they can be employed in family enterprise. Family enterprise means family business. Okay, means the business which is done by family only. But friends, this family enterprise word is very very controversial. Why? Because what happens in Indian village is that almost every person is a relative of other person. So what people do, people send their children for working with their relatives. Okay, and they are legally right also. Why? Because family enterprise is allowed under Child Labour Act 2016. Okay, so this family enterprise word is highly controversial. Why? Because in Indian villages almost every person is relative of other person. So if your child is working under other person also, then also it can be said that this is a family enterprise because he is your relative. Then friends, it prohibits hazardous employment to child of age 14 to 18. Means for children whose age is below 14 years of age, they cannot do any work, they cannot be employed anywhere except entertainment industry and family enterprise. But children whose age is between 14 to 18 years, they cannot be employed in hazardous employment. Hazardous employment means the works which are dangerous, works in which there is a threat to life. For example, mining. So for example, if you are doing mining and you are under a mine, then there is a danger that the wall can fall and that the ball of mine can fall on you, the roof of mine can fall on you and you can die. Okay, so mining is a very very hazardous employment. So according to Child Labour Prohibition and Regulation Act 2016, no child between the age of 14 to 18 can be employed in any hazardous employment. Okay, but friends, earlier what was the practice? That there were total 83 employments which were declared as hazardous employment. But after this act, all these 83 employments are now grouped into three categories. The first category is mining, second category is explosives, and the third category is others. Okay, so now you can imagine what is the condition, because earlier there were 83 works which were declared as hazardous, but now only 3 works are declared as hazardous, and they are mining, explosives, and others. Now friends, let's move further. So friends, then comes Article 25. So what Article 25 says? So Article 25 guarantees to every individual twofold freedom of religion. Now what does it mean? It means that Article 25 provides to every individual, to every person inside the territory of India, 2 types of freedom of religion. Now let's study one by one those 2 types. So first type is freedom of conscience. Now what is freedom of conscience? So freedom of conscience means absolute inner freedom of an individual to mold or shape his religious belief and faith. Okay, so freedom of conscience means absolute inner freedom of an individual to mold or shape his religious belief and faith. Now what does it mean? It means that any person in India can believe in any religion. Any person in India can worship any god. If you want to believe in Hinduism, you can believe. If you want to believe in Islam, you can believe. If you want to believe in Christianity, Jainism, you can believe. Nobody will stop you. Means if you want to believe in any religion, if you have faith in any religion, you can do so. Similarly, friends, if you want to worship any god, you can worship. If you want to worship Krishna, if you want to worship Lord Ram, Goddess Durga, Goddess Kali, Allah, Jesus Christ, you can worship anyone. Okay, so nobody will stop you. So freedom of conscience means you can have faith in any religion, you can worship any god. Okay, you can shape your religious beliefs and faith as you want. Now friends, this is inner freedom, means this is something in your mind. You are thinking in your mind that I am believing in Hinduism. You are thinking in your mind that I am a devotee of Lord Krishna. But when this inner freedom takes an outward expression, so outward expression means when you are doing something in this real world, means now you are not doing something in the world of your mind, because when you are believing in Hinduism, you are actually believing it in your mind. When you are a devotee of Lord Krishna, you are just thinking in your mind that I am a devotee of Lord Krishna. But when you actually start doing these things in real world, okay, so when these inner freedoms takes an outward expression, means when you start expressing your ideas, okay, then it is called as right to profess, practice and propagate a religion of one's choice. So this is the second freedom which is guarantees. So second part is right to profess, practice and propagate a religion of one's choice. Now what is right to profess? So right to profess means right of an individual to speak about his religious beliefs freely and openly. Now what does it mean? So suppose friends, if I believe in Hinduism, if I am a devotee of Lord Krishna, then I can tell about the works of Lord Krishna to anyone. I can recite the stories of Lord Krishna to any person. Nobody can stop me. Police cannot stop me. Government cannot stop me. People from other religion cannot stop me. Okay. So if I believe in Hinduism, if I am a devotee of Lord Krishna, then I can tell about the works of Lord Krishna. Then I can recite the stories of Lord Krishna to any person. Okay, then I can hold seminars, I can hold meetings, I can call people in the meetings, and in those meetings, I can teach people about the works of Lord Krishna. Okay, so it means that every individual has a right to speak about his religious beliefs freely and openly. Okay. Now what is right to practice? So right to practice means right to follow the rituals prescribed by the religion and display the symbol and signs associated with the religion. Now what does it mean? So again I will give you one example so that you can understand it very easily. Suppose friends, I am a follower of Hinduism. Okay, just suppose I am a follower of Hinduism and I am a devotee of Lord Vishnu. Okay, so I am a devotee of Lord Vishnu. So if I am a devotee of Lord Vishnu, then according to Hindu religion, what I should do, I should actually keep fast on Thursday. So I can keep fast on Thursday, and what I have to do, I have to wear yellow colored clothes on Thursday. I have to eat yellow colored food on Thursday, and I have to worship Lord Vishnu on Thursday. I have to go to the temple of Lord Vishnu on Thursday. Okay, so it means that any person has the right to do what his religion prescribes for him. Okay, any person can display the symbols and signs which are associated with the religion. For example, in Islam, it is prescribed that people should keep beard, okay, and they should bear a kind of cap. Okay, so people of Islam bears a kind of cap, and they also have beard. Similarly, the people from Sikh religion, they bear turban. Okay, and they keep kripan. So what is kripan? Kripan is a kind of weapon. Okay, so it is allowed under their religion that they can keep kripan. Okay, and they can bear turban. So right to practice means you can practice your religion. It means you can follow the rituals prescribed by your religion. If your religion says that you have to bear turban, then you can bear turban. If your religion says that you can keep kripan, then you can keep kripan. Okay, and to display the symbols and signs associated with the religion. For example, people from Christian religion, they are allowed to wear cross symbol. Why? Because this symbol is associated with the religion. Okay, means I can practice my religion. I can do anything which is written in my religion. Now what is next point? So next point is right to propagate. Right to propagate means to spread the religion by seminars, cultural events, writing books and converting person's religion, but not by force or temptation. Now what does it mean? So friends, again I will give you one example. So suppose I am a follower of Hinduism and I am a devotee of Lord Krishna. Okay, so now I can hold meetings. Okay, I can keep seminars. Okay, I can keep seminars and I can invite people in these seminars. I can organize cultural events and I can invite people in these cultural events. And in those seminars and cultural events, I can tell people about the works of Lord Krishna, about the stories of Lord Krishna, and I can also explain people about the Hinduism. Okay, that Hinduism is a very beautiful religion. Okay, so I can explain people about the Hinduism or any religion which I believe in. Okay, and then I can request the people to change their religion. Okay, so suppose if I am a follower of Christianity, so then I can request the people to join Christianity. Suppose I am a follower of Jainism, then I can request the people to follow Jainism. And suppose if I am a follower of Hinduism, then I can request the people to join Hinduism. Okay, so right to propagate means you have the right to spread your religion. You can request other people to join your religion. And how you can do it? You can do it by conducting seminars, by organizing cultural events, by writing books, okay, and converting person's religion. But friends, there is a condition. You cannot force anyone to change his religion, and also you cannot temptate anyone to change his religion. For example, suppose if I am a follower of Hinduism and I conducted a seminar, and in that seminar I told everyone about the stories of Hindu gods. Then I requested all to change their religion to Hinduism. But I can only request, I cannot force them. I cannot force them means I cannot say them that if you will not change, then I will punish you. If you will not change, then I will kill you. So I cannot do so. I can only request them. Secondly, I cannot temptate them, means I cannot lure them, means if you will change the religion, I will give you 1 lakh rupees, or I will give you 1 kilo rasgullas, okay, or anything. So I cannot temptate them that if you will do this, then I will give this thing to you. So I cannot temptate them. And friends, in Madhya Pradesh and Odisha, first you need to take the permission of district magistrate. Means if you want if a person wants to change his religion, then he has to first take the permission from DM, means collector. Okay, so you have to take the permission from district magistrate if you want to change your religion. This is a law in Madhya Pradesh and Odisha. Now friends, then came Father Stanlaws versus State of MP case 1977. So let's see what Supreme Court said in Father Stanlaws case. So first of all, Supreme Court said that fundamental right of a person to spread his religion by explaining the content cannot be questioned. Now what does it mean? So it means that suppose if I am a follower of Christianity, okay, and if I am telling about the content of Bible, about the works of Jesus Christ to the people, and after telling people about the works of Jesus Christ, I am telling them that now if you want, you can join Christianity. It is your choice. Then no problem. Then state cannot stop me. Police cannot question me. So this was the first thing. The second thing was there is no fundamental right to convert others to one's own religion. Now, what does it mean? It means that suppose I am a follower of Hinduism, okay, and what I am doing, I am going here and there, means I am visiting many places, and there I am telling people about the stories of Hindu gods, about the glory of Hinduism. And then I am saying that now you have to join Hinduism. Then I am forcing them. So it means that I do not have any fundamental right to convert others to my religion. If they want, they can come. If they don't want, they cannot come. Means it is their choice. It is their voluntary choice. It is not my fundamental right. I can only request them. I cannot force them. Now, what is the third provision? So, in case of faith and belief, the fundamental right enjoyed by the individual is absolute, and state cannot interfere in it. Now, what does it mean? It means that if I want to believe in Hinduism, Islam, Sikh, Jainism, I can believe. Nobody can stop me. Government cannot stop me. Similarly, if I want to worship Lord Krishna, Lord Rama, Goddess Durga, Goddess Kali, or Allah, or Jesus Christ, then nobody can stop me. Means until things are in my mind, till then, state cannot stop me. What I am thinking in my mind, definitely state cannot control it. So until I am thinking in my mind that I am a devotee of Lord Krishna, state cannot stop me. I am a devotee of Allah, state cannot stop me. Now, what is the fourth thing? So, but in the case of religious conduct and practices, state is free to regulate in the interest of society. So friends, I will give you one example so that you can understand it very easily. So friends, once what happened during an exam in Aligarh Muslim University, that definitely women were wearing burqa, and authorities found that these women were doing cheating. Okay, so then the university authorities, they banned the use of burqa, means they banned the wearing of burqa inside the exam hall. Then what happened? That the religious authorities, they filed a case in Allahabad High Court. And what Allahabad High Court said, that Allahabad High Court declared that the use of burqa cannot be banned even in the exam hall. Why? Because this is unconstitutional. This is against the right to practice one's own religion. Okay, so this is unconstitutional. So Allahabad High Court banned this decision. Then what happened? These authorities who banned the use of burqa during the exam, they took the case to Supreme Court. And then what Supreme Court said? Supreme Court declared that banning burqa for 3 hours would not take away the right to religion. Okay, so what Supreme Court said, that if the burqa is banned only for 3 hours during the exam, then your right to religion is not violated. Okay, so finally what Supreme Court ordered, that now burqa is banned during the exam. Means if college authorities want, university authorities want, they can stop you from wearing burqa during the exam. Okay, and this was important to stop these girls from doing cheating, so that exam can be conducted in a free manner. So this was the fourth point. Means in the case of religious conduct and practices, for example, what is burqa? Wearing burqa is a religious practice. So state is free to regulate the interest of society. Means now state is free to manage these religious conduct and practices in the interest of society. Okay. So friends, then comes Article 26. So what is Article 26? So Article 26 says freedom to manage religious affairs. Now what does it mean? So let us study this article in detail. So Article 26 says that subject to public order, morality and health, every religious denomination or any section thereof shall have the right A. to establish and maintain institutions for religious and charitable purpose. B. to manage its own affairs in the matters of religion. C. to own and acquire movable and immovable property. D. to administer such property in accordance with law. Now what does it mean? So friends, now first of all question arises that what is religious denomination? So religious denomination means a religious group. For example, Hinduism is a religious denomination. Islam is a religious denomination. So what is religious denomination? Religious denomination means religious group. For example, Hinduism, Islam, Christianity, Jains. Okay, so they are religious denomination. Now what Article 26 says, that all the religious denominations, for example, all the religions, they have the right. So what is the first right? First right is that to establish and maintain institutions for religious and charitable purpose. Now what does it mean? It means that all the religions have the right to establish their institutions and then to manage their institutions. For example, Hindus have right to establish their temples and then manage their temples. Similarly, Hindus have right to establish their ashrams and then to manage these ashrams. Similarly, Christians have right to establish madrasas and then to manage these madrasas. Means all the religions have the right to establish their religious and charitable institutions and to maintain them. Okay. Then comes second part, means B, to manage its own affairs in the matter of religion. Means all the religions have the right to manage their religious affairs. Okay, so all the religions, whether it is Hindu, Islam, Sikh, Christianity, all the religions, they have fundamental right to manage their affairs in the matter of religion. Means they have the right to manage their religious affairs. For example, it is the authority of the head priest of the temple in Hindus. It is the authority of the head priest of the temple in Hindus to decide that what manna is to be offered to God. Manna means prasad. Okay, so what prasad is to be offered to God, it is decided by the priest. Definitely, what clothes people should wear during prayer, it will be also decided by the priest. Similarly, which prayers will be offered to God, it will also be decided by the priest. Okay, and all other things. There are many other things. Means the religious institutions, the religion has the complete authority to manage its religious affairs. But friends, there is a condition that religion cannot interfere in the secular affairs. For example, if you will give shelter to any terrorist or criminal in a religious place, then state can act upon you. Means then police can enter inside the premises of the religious place and then police can arrest the terrorist. Means secular affairs will be managed by the state. Okay, but religious affairs will be managed by the religion only. For example, it is the authority of the priest to decide that today which prayer should be offered to the God. Now what is third part? So C and D we will read together. So C is to own and acquire movable and immovable property, and D is to administer such property in accordance with law. Now what does it mean? So for example, suppose in Hinduism, temple authorities has the right to own land. So what is movable property? Movable property means property which can be moved. For example, gold is a movable property. Why? Because we can move gold from one place to another. What is immovable property? So land is a immovable property because we cannot move land from one place to another. So religion has the right to own and acquire land, gold and other kind of properties. And religion also has the right, means every religion also has the right to administer these properties in accordance with the law. Means they will do this in according to the law of the land. Okay, means okay, so all the religions have fundamental right to own and acquire any movable or immovable property, for example gold, silver, land. Okay, and to administer these properties in accordance with the laws, means to manage these properties. So friends, let's move further. So then comes Article 27. So what is Article 27? So it prohibits the state from spending tax collections from the promotion and maintenance of any particular religion or religious denomination. Now what does it mean? So friends, it means that we all know that Government of India collects tax and state governments also collect tax from people. For example, income tax is collected, GST is also a tax. Okay, so government collect tax from us. Now government cannot use this tax money for the promotion of any one religion. For example, government cannot use this tax money for the promotion of only Hinduism, for the promotion of only Islam or any other religion. Okay, so government cannot discriminate between the religions. Government cannot use the money of tax money for the promotion and welfare and maintenance of any particular religion. Now friends, it means that it truly brings out the secular character, secular nature of Indian state. Why? Because money is the most powerful thing. Money is power. Okay, so if state is prohibited from using tax money for the welfare of one particular religion, means practically state cannot favor any particular religion. Okay. Now friends, Article 27 doesn't prohibit the state from spending tax collection for the promotion and maintenance of all religions without any discrimination. Now what does it mean? It means that if government wants to use the money collected from the taxpayers, the money came from tax, okay, for the maintenance, for the promotion of any religion, then government has to spend same amount of money for the promotion of all other religions. For example, if government spends 100 rupees for the maintenance of Hindu religion, for the promotion of Hindu religion, then government has to spend 100 rupees for the promotion of Christianity, Islam, Jainism, Buddhism and all other religions present on the inside the territory of India. Okay, means government cannot discriminate between the religions. So if government want to use tax money for the promotion of one religion, then government has to do this for all religions. Means government can spend this money for the promotion of all religions without any discrimination. Similarly, friends, Article 27 doesn't prohibit the state from spending non-tax collection collected in the form of fee or religious donation in spending for promotion or maintenance of even a particular religion. Now what does it mean? So I will give you one example so that you can understand it very easily. Suppose, friends, what happened in Hindu religion once, that there was a seminar, okay? There was a seminar about the religion, about the practices in Hindu religion, and there was an entry fee of 100 rupees. Okay, so the seminar was of particularly Hindu religion. Okay, and who was taking that seminar? Definitely a Hindu Dharma Guru was taking that seminar. Why? Because the Guru was telling the people that these are the practices which a Hindu should do in his life. Okay, so Guru was actually teaching everyone about the religion, and there was an entry fee of rupees 100. And suppose 10,000 people joined the seminar. Okay, so if 10,000 people joined the seminar, so how much money is collected? So definitely when you will multiply 10,000 with 100, so you will get that 10 lakh rupees is collected. Okay, so now government can use this 10 lakh rupees for the promotion of Hindu religion only. Why? Because this money is collected as a fees. Okay, only from Hindu religion. Okay, and government can do similar practice with other religions also. So now government can use this money for the promotion of only Hindu religion. Okay, and government can also do same thing with other religions also. Okay, so this was the meaning of last point. So friends, that's all for today. In the next class, we will continue our discussion with Article 28 of the Indian Constitution. So friends, I hope that you all must have enjoyed the lecture. So if you have enjoyed the lecture, so please like the video, comment on the video, share this channel, share this video, subscribe to my channel, press the bell icon and share this channel to at least 10 people you know who are preparing for UPSC or any other state PSC. Till then, take care of yourself. Thank you.